Good morning, all. This application hearing is in the matter of CFI 092-2024 before His Excellency Deputy Chief Justice Ali Madhani. The claimant is represented by Mayor Brown. Lead counsel is Mr. Martin Koshdell. The defendants are represented by Aker Choquette Advocates and Legal Consultants. Lead counsel is Mr. Jordana Dre. Thank you, Your Excellency.
Thank you very much, Radia. Good morning again, councils.
Morning.
Good morning, Your Excellency.
You have an application to remove D2, D3 from this, from the substantial claim.
Absolutely.
We have the application, and I had the pleasure of reading your submission. The defendant submission, it's about 11 pages of skeleton argument and 25 pages of the opposite counterpart, plus the rest of witness statement and supporting evidence, especially the emails related to the transactions. Yes, Mr. Dre, you may please the court.
Everyone. Yes. Good morning, Your Excellency. Before just getting into the topic, I apologize in advance. Apparently, they decided to do some drilling upstairs. So far, it was not so bad, but I really hope it won't impact the hearing. I do apologize. I don't want to echo to my case with force majeure, but honestly, it was not planned. That's for just the nuisance that might interfere. And to echo your issue with the IT, we had many issues in the case regarding either the bundle upload or even the order to be attached, because for reasons that were out of our control, the order was not appearing when I was actually filing the applications. That's why it looks this way, which is not the best, but it was the only option that was working, and I did it in accordance with the case manager officer and the IT team. And I didn't attach the skeleton arguments and the authorities to the bundle because I was afraid of triggering any issue with access or modifications. So I apologize for that. And that was the little IT point I wanted to make.
No problem. I wonder if Mr. Chudel is facing a similar problem.
I haven't tried,
Let's see.
so I don't know.
Yeah,
I'm not the part one practitioner. I don't know.
No, but my colleagues, Ms. Sinjab, witnessed the issues when we shared the bundles communication, because, for example, once uploaded, it's the same version for 60 days, even though you modify or update the bundle. The party that had the communication and download it cannot re-download it with the updated version. And this was brought to the IT team, and they said they're trying to fix the issue. But this was one of the inconveniences we were facing, and therefore I didn't want to risk any additional problem.
Not all, but when you mean IT team, do you mean the court IT team or your firm?
No, absolutely. The DIFC court's IT department, and Ms. Shamsi was copied to the exchange of emails. So she was informed about the issue we're facing.
Alia, you confirm?
Your Excellency, I do know that defendants were having issues with filing. Whether this was due to the portal issues or due to a system error, I can't confirm that.
Okay, let's investigate this and look at it at next time after the hearing.
Of course.
Please, Ms. Ray, you may proceed.
Thank you.
Any other housekeeping issue?
No.
No?
So far, no.
I just check. I'm sorry, just before Mr. Dre begins, can I just check that Your Excellency has received the authorities that both parties rely on? At least, do you have the PDFs? So that
Yes, I got it in PDF, yes.
So we can refer you to the PDF. Perfect.
Yeah, Mr. Ray?
Yes, may I? Yes. Okay.
Yes.
Am
I addressing you in the right form? I mean, Ray, yeah?
Yeah, Dre.
Yeah.
Yeah. Easy, simple, and short. Today, the hearing is about the application that the defendants made pursuant to Rule 24.1 of the RDC for immediate judgment in respect of the claim that was brought by Development Services Ltd. On the ground that the claimant has no real prospect of succeeding on its case by suing personally Mr. Laurent Buisine and Mr. Hugo Vallin as party to the tenancy agreement. Exchange were made, and the bundle include the extension of time application that were made by the defendants. But I want to just emphasize that it was at the request of the claimant, and that the defendant didn't see the use to add such an application. But I will let the claimant explain the reason why he insisted deeply on having this application included in the immediate judgment bundle. This application is actually very straightforward. That's why my skeleton argument is relatively short, because the position of the defendant is that it's a very simple and basic point. And to support this actually statement, we can refer to the case management memorandum that doesn't even list this issue as an issue. So sorry for the redundancy, but if you pay attention, the case management is summarizing it in one of the requests of the defendants, but at no point is listing the fact that defendant 2 and 3 were sued as a proper issue. That's why, in the light of the exchange that were done between the parties and the development and communication of evidence with disclosure of documents, it came as a kind of evidence and obvious orientation that this issue is suitable for immediate judgment. So the criteria for immediate judgment are very clear and perfectly stated by the case law and authorities. You will see that actually the defendants and the claimants are referring to a lot of common authorities, which prove that they are not disputed and that they are agreeing on the condition that supports immediate judgment application. Basically, the claimant, the defendant, the applicant has to demonstrate that the claimant has no real prospect of succeeding on the claim or issue against D1 and D3, and that there's no other compelling reason why the case should not be disposed of at trial. I will go in details on all the applicable criteria that are following those conditions and that were brought by the different authorities that were referred by the parties for this hearing. But before that, I want to do a detailed factual background, because I think that it's very important to state clearly what is the situation at stake and why we are here today. So everyone is familiar now with the case because we are advanced and we're not in the beginning of the proceedings. So I won't go into the details. We know that the defendant created a company in the AFC in order to promote a kind of private club for luxury car collectioners, and that the premises and the strategic place was the location that is object of the tenancy agreement that will be referred to in this hearing. So today I won't go in deep about all the facts of the case, because this is not what matters here, and it was not the purpose of this application. What we will focus today is on what is the actual contractual situation that supports this application. So basically, Laurent Buisine and Hugo Vallin are the shareholders and the managers of CCRL Dubai that was incorporated in DFC. So there are people, and they came to actually develop a project and entered into negotiation with MAG Services and agreed on a certain amount of conditions and terms in order to sign the lease agreement. So the initial draft of the lease included all the defendants as proposed tenants, and this is clearly illustrated on many occasions during the exchange of documents, whether in the submission of the exhibit of the claim itself at page 41 of the bundle, or the different development submitted for this application, page 596 of the bundle. And I don't think there's any dispute on that. And the claimant and the applicant agreed that the representative of the company will be removed from the contract once the license is obtained. And this condition was also, as mentioned by the claimant, one of the conditions that was stated in the previous tenancy contract with Red Rose Restaurants, and therefore is no innovation here. But it has been agreed by exchange of email that once it will be done, then the physical representative of the company would not be part of this agreement anymore. And it's very important to pay attention to the wording and to the way the emails were exchanged, because it's a conditional signature of the tenancy agreement. And I apologize for that, because I will have to read it, and I do apologize for my accent that is sometimes very strong, but it's important for the arguments at stake that it's clearly labeled in front of the court. So on 16th of August 2023, the Hugo Valla and Laurent Buzine wrote to the landlord representative, who is Mr. Louay, and explained in details the following. In reference to our discussion related to the lease agreement to be executed between MAC Development and the Collection Club Restaurant Limited, which is page 614 of the bundle, we have reviewed the new version of the agreement provided, and we have found the same in line with our latest interaction. However, we would like to highlight and agree that once the UAE company license is issued and provided within the time frame mentioned in the agreement, no later than 3 months, which equals to clause 5 of the lease agreement, an addendum to the lease agreement should be added stating that the sole tenant is the registered company, and that use of the premises and responsibilities under lease shall be exclusive under the name of the same company. So here, there's no doubt that in order to finalize and execute the tenancy agreement, the condition is that first, the defendants register the license within 3 months from the signature of the tenancy agreement, and provided that it is done, then Hugo Valla and Laurent Buzine won't be part of this tenancy agreement anymore. And the exchange of email is pretty straightforward. On that, I want to echo to the arguments that were brought in the skeleton's argument by the claimant, because it is not negotiation. It is not preliminary negotiation. It's a condition that is imposed in order to execute the contract and to proceed to signature. Like, there's no doubt, absolutely no doubt about the party's intention in the way this was written. So I clearly disagree with the reading and interpretation that was made by the claimant at paragraph 46 and 87F of their skeleton arguments. And this echoed the fact that the claimant himself answered page 609, "Dear Laurent, hope you are doing well. Further to your email below, kindly note that we confirm the below. Please arrange to sign the lease agreement and send it to us ASAP." So, technically speaking, it's a done deal, if I may say. Why? Because we have a precondition for execution that was brought up by the applicants. And then the representative of the landlord says, "I confirm the below," which means there's a clear stated agreement on the precondition that once the license is obtained, Hugo Valla and Laurent Buisine are no longer part of this tenancy agreement. And it's so logically that consequently, page 614, in the exchange of email, Laurent is answering, "Dear Louai, please find accordingly," and I emphasize accordingly because it does matter in the situation at stake, "the lease signed." Therefore, the meaning, effect, and agreement between the parties could not have been clearer. The applicants were not to be parties to the lease once the license has been granted. And it will be demonstrated that actually in the execution and the following events, all the parties behaved in accordance with this statement. And the fact that the claimant in paragraph 51 of his skeleton said that it's at a future date that is uncertain to be enforceable is totally inaccurate, for the very simple reason that the license has been enacted or registered probably and communicated to the defendants beginning of September and was retroactively valid since June. So it was even before the tenancy agreement was signed. Therefore, there's no whatsoever question about the fact that this condition was filled. And there was no reason for the defendants to formally state that the license was obtained because it was obvious. And when it's obvious, you don't feel the need to submit additional documents. Therefore, in echo to the request...
Mr. Dre, may I ask you what date the signed agreement were sent by Mr. Laurent to the company?
16th of August, Your Excellency.
Oh, August 16th. So the conversation started 13?
Yes.
And it's ended, yeah, 16th of August. So all of the correspondence was on the 16th, same date?
No, actually, Mr. Louai Al-Sabouni answered with his counter-signature of the tenancy agreement on the 6th of September.
Yes, wait, yes.
And there were in between some exchange that were actually part of the first exhibits of the claim and of the particular of defense, where some emails were actually making reference to the handover documents, but I will talk about it later. And
then what happened? So Mr. Laurent said, "Please find accordingly the lease signed."
Exactly.
And then next, what happened?
And then the parties, I mean, at least the applicant, considered that it was a done deal because basically on the 6th of September, the license was already obtained. And based on the exchange that were made in the case, I mean, not for this application, but overall, you can clearly understand that nothing would have been possible if the license wouldn't have been obtained. Means the registration of the lease agreement in front of the AFC authorities wouldn't have been possible if the company was not in existence. The request for non-objection certificate wouldn't have been relevant. The execution of the repairs and work in the premises couldn't have happened if the company was not existing. So basically the exchange between the parties are clearly illustrating that there was a very fluid communication and direct communication throughout all the time that things were working before, you know, things get less profitable and there were delays in payment. But even when there was delays in payment, I mean, there was a communication between the parties. So based on that, and, you know, also referring to the fact that we are dealing with people that are developing projects that are businessmen and that are usually very practical and straightforward people. Therefore, they're less into formalities than, you know, us that are part of the legal world. And I think that once things are very straightforward, there's no debate. I mean, the license is granted, the lease is signed, they agreed on the condition, they start execution. Why would there be so many steps? You know, it wouldn't be logical for the world that this project is part of. So basically, the things we're going through in a very logical way. The commercial license was granted. You have a sample of it at page 631 of the bundle, and it was actually in force as labeled since 6th of June 2023. So there's no question about its validity or the fact that actually the defendant did have a valid license. And then just to prove and to confirm the position, on the 29th of August, in accordance with the development of the project, actually, the claimant agreed to provide a non-objection certificate to the defendant. And what is really important is that if you want to check the NOCs, they are page 753 and 754 of the bundle. And it's very straightforward. We, MAG Services, landlord, owner of the Emirate Financial Towers floor S26 and S27, the property, hereby confirm that the Collection Club Restaurant Limited, the tenant, is leasing the property. So, based on the statement that were made previously, it's a perfect illustration that there's no question between the parties because they are behaving as the lease was actually just between the Collection Club Restaurant Limited and MAG Services. Because if we pay attention, the wording is, furthermore, the landlord has no objection for the tenant to serve alcohol to their customers. The letter is issued upon the request of the tenant and comes without any commitment or liability from the landlord or its official and subject to DIFC and authority approvals. Based on that, it's very clear that for everything that matters, the only tenant is the company. There's no mention whatsoever of Laurent Buisine and Hugo Valla at all, and it's signed by the landlord. So the document is really official in its way. We are very surprised that it hasn't been disclosed by the claimant, actually. In the intensive work we had to do to answer to the disclosure, we found those documents. So we were very happy and surprised that no mention has been done at all. And to emphasize it, even the letter which is stating the takeover of the unit that was attached in the emails that I previously mentioned, the takeover certificate is very clear because it's addressed to the company and not to the physical individuals. So if we continue on that path, just to confirm that there's no interpretation that could divest this position. On 1st of September, the lease was registered with DIFC only under the name of the first defendant, page 632 of the bundle. And it's straightforward. So the position of the claimant is that it's a self-serving document, quoting the paragraph 70 and 73 of the skeleton argument, but it's not a self-serving document. It's part of the normal procedure that the tenant is actually registering the lease to the DIFC authorities. And if, because the claimant has a notification that it has been done, because it's a precondition to start all the registration for HRA and electricity, water, and so ever, if there was any issue, the claimant could have objected and said, no, you didn't register all the tenants. But nothing was done. Nothing was done. So then on 6th of September, the claimant countersigned the contract, but it's page 609, 611 of the exchange of email that we just covered. And the condition was already realized, and we had all the supportive documents that prove that the license was actually valid, because otherwise the registration of the lease wouldn't have been possible within DIFC registration authorities. So the applicants were not intended to be parties to the tenancy agreement once the license was granted. And the detailed inventory that was made was important because it was fundamental to prove that the parties behaved accordingly. And even when the things were not going well and the relations started to be not damaged, but like less smooth because of the delay in payment of the defendants, it's very clear that it's only about the company. The party executed the amendment in writing, which is the best evidence because it's only proving the intention and the interpretation that was made. So it's only about the company. And yes, Hugo Valla and Laurent Buisine appears from time to time, but they are the manager of the company and they are the shareholders of the company. So if we go even on the amended particular of defense that were quoted, Your Excellency, I'm sorry, maybe I'll go fast. Let me know if.
No, I'm good with you.
Okay, great. So it was quoted by the claimant that the amended defense particular were referring to the three as an implied, acceptance that the three were indeed part of the tenancy agreement. So in order to rectify and explain that the statement doesn't stand, if you go further in the amended defense particular, you can see that page 73, paragraph 65, just after the title, the defendant's alleged purported termination of the lease, it's written, the defendant, singular, formally issued a notice of termination in accordance with the lease agreement terms. A bit further down, I think it's paragraph 68, the defendant issued a valid termination notice on the 24th of June 2024, sorry.
I think we've lost, I've lost the screen. I can't see the judge. I'm just
yes,
wondering if the judge is still there.
Oh, okay.
Oh, sorry, we lost you for a moment, Judge, so that's why we stopped.
Your Excellency, you got
Do
disconnected.
you see me now?
Yeah, we see you now.
Yes.
Yeah, I've been following. I
Okay.
can see, I can
okay,
hear
you
you.
were not disconnected. Okay. So basically, I was saying that even when it comes to the mention of the termination, it's pretty clear that the defendant is the company, and the way the amended defense particular are written, it's using the singular. So basically on that, I think things are very clear. And if we move even further regarding the exchange of letters between counsels, when the relations started to deteriorate, again, it's very clear because the correspondents are speaking out of themselves. Because White & Case law firm that was acting on behalf of the first defendant wrote a letter terminating the lease, and they referred to the tenant as first defendant, which is page 616, and it's the termination letter that is quoted and mentioned in many exhibit and appendixes in this bundle. But more interesting, on the 16th of September, Maya Brown, the actual counsel of the claimant, wrote a very formal letter to answer the termination. That is page 635 of the bundle. And on that, I will just take the time to read it, because for me, if this doesn't prove, then I don't know what else can prove the fact that the lease was actually amended. And there's no mention in the claimant skeleton of this element, surprisingly. So, dear Julian, and it's a letter from the attorney.
What page are you reading now? What page are you reading now?
Page 635, Your Excellency.
635.
So, dear Julian, the title of the letter is Level 26 and Level 27 at Emirates Financial Tower, the premises. Lease agreement dated 15th of August 2023 between MAG Development Services Limited, the landlord, and the Collection Club Restaurant Limited, the tenant. In relation to the premises, we act for the landlord. We refer to the lease annual letter dated 24 June 2024, addressed to our client. We acknowledge your letter, which sought to terminate the lease in accordance with clause 32 of the lease, effective 23 of June 2025. We are writing to inform you that the landlord now wishes to terminate the lease in agreement with clause 30A. We will provide written notice to terminate under separate cover. Why it's fundamental to pay attention to this letter? Because the council took very good care to list all the key elements of the tenancy agreement, i.e. the premises, so there's no misunderstanding about the location and the premises, the landlord, which is clearly identified, and the tenant. And the tenant is labeled the Collection Club Restaurant Limited. There is no mention whatsoever of any other tenant. And this is the best evidence that the lease was indeed amended. Because why? Mayor Brown, that is also here right now, and is arguing that the other two are part of the tenancy agreement, wouldn't add them. It's just being pragmatic here. Why? As we know how lawyers could be peculiar and in details, because devil resides in details, wouldn't precise that condition. If it's that clear and obvious that they are part of the tenancy agreement, why in a termination letter they wouldn't indicate it? While all the key elements of the tenancy agreement are indeed indicated here. And why there's no mention of this letter in the claimant skeleton? It was in the exhibit. It's clearly used as a supportive document for the immediate application because it's the best illustration of the statement that were made. And therefore, I mean, there's no other tenant but the company, and the claimant wrongly started the proceeding alleging that the applicants, which is Laurent Buisine and Hugo Valla, were parties to the tenancy agreement. Because through all the developments, they're strictly absent about it. And the preliminary condition to the execution of the contract was filled. So everything has been done. I don't want to say bad faith, but it's a very big stereotype. But I must emphasize the fact that there's no clear reason that supports the fact that Hugo Valla and Laurent Buisine were indeed included in the suit. And contrary to the argument that were raised by the claimant, I mean, there's no reason for estoppel here. There's no point of raising the fact that the applicant should have raised it before, and they should have amended defense particular, and so on and so forth. And it echoes to the paragraph that are running from paragraph 29 to 39 of the skeleton argument, sorry. And also, I think in the paragraph 87, and it's very interesting to pause a bit on this concept that was actually mentioned a few times in the skeleton arguments of the claimant. Because basically, estoppel is denying or contradicting, sorry for diction, a statement or action they have previously made. So I raise the question here, who should not be allowed to raise this argument, the defendant or the claimant? Because all of a sudden, you have a turn of 180 degrees of the claimant saying that, oh no, by the way, Hugo Valla and Laurent Buisine are part to this agreement. But you didn't implement that before. You didn't mention them. You agreed to the precondition to sign the lease. So the argument brought by the claimant here is actually totally irrelevant and lacks a lot of strength. So now that the facts are properly stated and clearly brought, I would like to move to the legal framework that supports the application, even though like facts are pretty clear and we talk about contract law. So a lease constitutes a contract and it governs by the principle of an offer, an acceptance, and a mutual agreement. I think that the factual background that have been done perfectly illustrate that those conditions were actually realized and proven here. We have an offer, we have an acceptance with conditions, and a mutual agreement in the execution. Article 14 of the contract law provide that a contract may be amended by agreement between the parties. The identity of the parties to a lease is fundamental and cannot be altered except with the express consent of all contracting parties, which consent was sought, given, and agreed in this case. So if we want to go even more in details and refer to the real property law of the AFC, it's law number 10 of 2018. It recognized that only those named in the lease as tenants are bound by its terms or liable for breach thereof. Any amendment to add or remove parties must be evidenced in writing. And I emphasize the evidenced in writing and with the consent of the affected parties, which is clearly evidenced by the emails in our case. So if this was not even strong enough arguments, Article 31 of the DIFC contract law states that a contract in writing which contains a clause requiring any modification or termination by agreement to be in writing may not be otherwise modified or terminated. However, a party may be precluded by its conduct from asserting such a clause to the extent that the other party has acted in reliance on that conduct. Here we are. So the argument brought by the claimant at paragraph 68 of the skeleton argument, qualifying the use and the reference to Article 31 as misconceived or misplaced, is irrelevant, because I don't see why Article 31 in this specific case would be misconceived or misplaced. And actually, there was no supportive argument explaining why in the skeleton arguments. Now, Article 49 of the contract law states the intention of the parties. And it's explaining in a very clear way that a contract shall be interpreted according to the common intention of the parties. Subject to Article 49.3, if such an intention cannot be established, the contract shall be interpreted according to the meaning that reasonable person of the same kind as the parties would give to it in the same circumstances. As regard a hybrid contract or coded contract, if an intention under 49.1 cannot be established, the contract shall be interpreted according to the meaning that a reasonable person with a competent understanding of the relevant code and having regard to the circumstances under Article 51 shall give to it. So let's go to Article 51, relevant circumstances. Relevant circumstances in applying Article 49.50. Regard shall be had to all the circumstances, including preliminary negotiation between parties, practices which the parties have established between themselves, the conduct of the parties subsequent to the conclusion of the contract, the nature and purpose of the contract, the meaning commonly given to terms and expression in the trade concerned, and usage. So I don't see, as mentioned in skeleton argument paragraph 69 of the claimant, any erroneous or incorrect interpretation of the contract law applied here. Why? Because it's clear we had written evidence supporting the amendment of the contract, and it was a precondition, and I insist on that, for signature and execution, that once the license was granted, the physical individuals included in the tenancy agreement, i.e. Hugo Valla and Laurent Buzine, would be removed from the tenancy agreement. It has been factually, materially proven by the documents that followed the execution of the contract, emphasize even the letter from Maya Brown regarding the termination of the tenancy agreement itself. And therefore, there's no reason why those individuals should be considered a party to the lease agreement. The executed lease with its correspondence and supportive documents demonstrate that the applicants are no longer parties, nor they are guarantors. I mean, when I read this argument that they can be considered as guarantors, I was like, okay, so basically we are rewriting history totally. From additional tenants, they become guarantors based on what? We don't know. Never happened before, was never mentioned before, never popped out. Nevertheless, it was a condition or an argument, sorry, that was raised as difficulties to interpret the contract that might have arising from this situation. Well, I'm sorry, we are all legal practitioners. What has a meaning? A guarantor is a guarantor. The status of a guarantor is clearly defined by laws and articles. And it's just not right to insert it as a fantasy in order to brought a diverse interpretation of contracts. The contract is clear. There's no ambiguity. There's no hesitation whatsoever about the intentions of the parties. You have clear documents that are supporting that. So bringing now the fact that it can be interpreted as guarantors, certainly not. So if we summarize, the applicants do not have any obligation under the governing law of the contract, as there was an unequivocal precondition to the signing of the tenancy agreement. Reference made to the emails between page 609 and 615, sorry, of the bundle. The precondition was fulfilled because the license was obtained, and there's no doubt, and it's not even contested. So there was no breach whatsoever mentioned by the claimant of the defendants of their obligation. And the example of the license is print page 631 of the bundle. The amendment to the lease was confirmed, as could be understood from the subsequent legal documents, which refer only to the first defendant as the party to the tenancy agreement, page 616, page 635. I mean, all those documents were clearly listed, so I don't want to get back over and over on them. And the tenancy agreement was in effect, and this is never, like this has never been a disputed fact. The amendment is evidence in writing. So if we summarize, there's no reason that could actually justify the fact that those arguments are irrelevant or not sustained or not satisfying any of the conditions listed by contract law to support the position of the defendants. And it has never been a question of declaratory relief as brought up by the claimant, paragraph 29 and 64 of the skeleton arguments. I mean, the position of the defendant has been very clear since the beginning. There's no material breach of a contract when it hasn't been actually observed. Because as far as the defendants are concerned, it was amended. And only when the claim was brought, all of a sudden, the contract was not amended. Therefore, it really weighs a question, but certainly not about a breach of contract, but that would request a counterclaim or remedies based on declaratory relief for fundamental, non-fundamental breach. This is absolutely not the point here. And this is exactly the reason why it has been brought as an application for immediate judgment. So I'm going to get back now more to the justification of the immediate judgment application. The article 24.1 of the RDC are bringing very clear conditions. It means the claimant has no real prospect of succeeding on the claim or issue, and there's no other compelling reason why the case or issue should be disposed of at trial. So the list of issues, I won't talk about it again, but I made a parallel with the memorandum of the case management conference, and it's not even listed as an issue. And the claimant, in his skeleton argument, did a very precise and detailed recap from paragraph 30 and so on about the applicable authorities, justifying that the condition for immediate judgments are met. So we will just follow the criteria listed, as simple as that. And as the authorities are not contested and we are actually referring both to a lot of common authorities, I don't think there's any specific reason to contest or emphasize the authorities listed. Therefore, the court must consider whether the claimant has a realistic rather than fanciful prospect of success. And this was actually one of the main criteria that was stated by Swain versus Hellman, and confirmed within the DIFC courts in the case Investment Group Private Limited versus Standard Chartered Bank 2018, that are also quoted by the defendant and the claimant. We actually, if I'm not mistaken, have it also in our exhibits. So reference should be easily followed, page 108 of the bundle. And I mean, I think that the arguments brought are pretty realistic and very concrete. And the demonstration that was made are really, as much as possible, try to stick to a very strict and straightforward interpretation of the documents and of the articles of the contract law. I don't think there's any fanciful arguments, and the claimant cannot honestly bring any arguments against the position that was raised here, supporting the fact that defendant 2 and 3 shouldn't be included in the suit, because it has been demonstrated that the criteria were made. We have clear evidence, and we did in fact answer to many conditions that were brought by contract law applicable in DIFC. Therefore, I think that when it comes to the authorities and the criteria, the first criteria that are stated in the quoted cases, but also in GFH Capital Limited versus David Lawrence Haight, which is a case of the DIFC court dated 18 October 2016, with reference to the paragraph, page 50, page 54 of the authorities attached to the skeleton for Swain versus Hellman, 87 for GFH Capital Limited. And you can find also those cases at page 764 of the bundle. And I think that the fact that the applicants were not a party to the tenancy agreement following the grant of the first defendant license is clear. The claimant cannot pretend that there's a real prospect of success on this point. Also referring to General Trading LLC, Horton Holding Limited, dated, it's IG quoted page 764. and Nancy versus Narcissa 2023. I think it's also bundle page 788. I mean, I don't see how those arguments could be logically and materially counted by the claimant, and that he should keep the individuals in the claim. I mean, it wouldn't make sense. If we refer to the overriding objective, there's no compelling reason why this issue cannot be disposed as a preliminary issue. Why? Because the idea is to save cost and time. And if this is already resolved before trial, then we can focus on the main issue of the trial, which is the date of termination, which is the force majeure, which are the damages. And this is actually an important point, but it's not connected with the main dispute. It's a procedural issue with a material impact that included people that shouldn't have been sued from the beginning. And that's the reason why there was a real sense in bringing it in the immediate judgment application. This application is not coming as a surprise for the claimant, because the defendant initially raised the issue, tried to find a solution, but there was no way. So we served the application, and the applicants have justified this application according to Omar Ben Alam versus Natixis judgment, that it's page 755 of the bundle, but it's also part of our authorities. And sorry, I'm just looking for the right paragraph to quote. This is standard chartered. Yes, so according to paragraph 49 of this authority, that is CFI 016/2025, Omar Ben Alan versus Natixis, the RDC Part 24 permits the issue of an immediate judgment on part of the whole of a claim if the claimant has no real prospect of succeeding on the claim or issue, and there's no other compelling reason why the claim or issue should be disposed of at trial. An application for immediate judgment may be based on a point of law, the evidence, or lack thereof, or a combination of both. The applicant relies on the precedent set in AGPR General Trading Electric LLC versus Hortin Holding Limited 2021, and Nancy versus Narcissa 2023, to set a guideline for the threshold, being that the respondent must show that he has a realistic rather than fanciful prospect of success that carries some degree of conviction. And if the court is satisfied that it has all the evidence necessary for a determination of the issue or claim, then it should grasp the nettle and decide the point. It is the applicant's position that the lack of real cause of action and unsubstantiated point make the unpaid annual leave claim suitable for immediate judgment, because it was the essence of this case. Basically, here, I think it's pretty clear that the facts are speaking of themselves, and that the claimant didn't disclose any supportive documents that could counter the position of the applicants here. And basically, all the disclosure that was made even in the proceedings by the claimant are bringing no answer whatsoever on that point, whether confirming the defendant's position or infirming it. And the argument raised based on the answer of the defendants regarding the request to disclose further documents is absolutely irrelevant, for a very simple fact. It's that the request was formulated in asking for documents that were internally exchanged to support the amendment of the tenancy agreement. How? I'm sincerely asking the question. How could we have such documents? Because to the understanding of the defendants, it was a done deal, if I may say. The license was provided, all the documents were with the title of the company, no mention of any individual whatsoever. How could they have, knowing that we also talk to people that are in the entertainment industry, dealing with F&B, and they're not lawyers. Okay, so they do mistake. Yes, they do. But this is not the point. The point is, how could they have such a document? And that's exactly why the answer was that it is totally irrelevant. They cannot have documents like this. Why? Because it was not even a question for them. It was obvious. So yes, there's no document to disclose, and no, it was not a refusal to cooperate. It was just, this point was totally irrelevant. And it was even missing the point of the context. So that's just the short point that I want to be made about it. And to echo about one of the arguments that was brought by the claimant, that there should be more investigation, that there should be more interpretation. I mean, where are your documents? Where are your documents? You are claiming that there's a need that you never explained nor justified for more interpretation and more documents. And based on the case law that is actually also quoted in the authorities and in my skeleton arguments, when the respondent is bringing a need for more documents, well, first, he should justify the need. He should explain why there's a need for more documents. And this criteria is clearly stated in the Korea National Insurance Corporation versus Allianz Global Corporate and Specialty AG case, dated 2007. It's quoted and referred in the bundle, page 831, and it clearly states that
paragraph?
Paragraph 50, no, sorry. In my skeleton, it's paragraph 59. And in the bundle, the case is page 831. And in my authorities, it's page 77. And it provides...
I have the case open before me. I would like to hear what paragraph of the precedent you're referring to.
Oh, it's that if a party wish to rely on the likelihood that further evidence would be available, it must substantiate the assertion. It is insufficient to simply say that further evidence will or may be available. And I'm trying to look now the exact paragraph because I quoted it in my skeleton. Sorry for that. Sorry. This case, no evidence.
It read, if it wishes to rely on the likelihood of future evidence will be available at this stage.
It's basically...
That's paragraph 14.
Yes, I think
It's in the middle of
I-
paragraph 14, I guess. Yeah.
Thank you. Sorry. Yes, yes, absolutely. It is incumbent, thank you, Your Excellency. It is incumbent on a party responding to an application for summary judgment to put forward sufficient evidence to satisfy the court that it has a real prospect of succeeding in trial. If it wishes to rely on the likelihood that further evidence will be available at that stage, it must substantiate that assertion by describing, at least in general terms, the nature of the evidence, its source, and its relevance to the issue before the court. The court may then be able to see that there is some substance in the point and that the parties in question is not simply playing for time in the hope that something will turn up. It is not sufficient, therefore, for a party simply to say that further evidence will or may be available, especially when the evidence is or can be expected to be already within its possession, as it is the case here, which is, for me, the perfect illustration of our case too. For this reason, it is, respectfully submitted that the court grant immediate judgment in favor of the applicant, dismissing the claimant's claim against them, so Hugo Valla and Laurent Buisine specifically, and grant such further other relief as the court deems just and appropriate. The applicants are not and were not at any material time parties to the lease, and the claim against them is misconceived as a matter of law and fact and should be dismissed with cost. And I want to make my last parallel to the paragraph 87.k, L, M, and N of the claimant, because bringing the arguments that they could be guarantors, and then there's a question of interpretation of the emails, and then, and that was my favorite part, at paragraph 87L, there's no prejudice for defendants 2 and 3 to attend trial, to remain defendants as they are shareholders. Wow. And point M, yes, because they give direction to the legal representative so heavily involved, and they are anticipated to give oral evidence. We are legal practitioners, and honestly, defendants in a case has one meaning. Company manager, another one. Shareholder, another one. And witness in a case, another one. So I'll stop there, and I think that the point was made that even though they are indeed, yes, involved in the case, because they are shareholders of the company and they are managers of this company, it doesn't justify them to be added parties in a claim as defendants on a contract that was properly amended. Thank you.
Thank you very much, Ms. Ray. Until now, to Ms. Chadwell, would you like to take a break, or you're ready to go on? Your opponent has just taken just over an hour.
I'm okay to carry on if you're happy to sit.
I am happy. Yes, please. You may please the court.
Yes. Can I just clarify? It's I don't like to be pedantic over the pronunciation of my name, but it's Koshdel.
Koshdel, sorry.
Yes. Well, Your Excellency, I'm going to need to spend a bit of time on this because, unfortunately, I say with respect that my learned friend has misstated the facts and hasn't given you the full picture, and I'm going to have to take you through some of these documents again. And then what I'm going to do is demonstrate why her analysis is flawed, because I'm still left a little bit confused as to exactly what her primary case is and then what her alternative cases are going to be on this point. But what I've tried to understand in my skeleton argument from paragraphs 24 onwards is, sorry, maybe it's a bit later than that actually, but is paragraph 36 onwards, I think, is if there is an implied obligation, how is that an obligation to be enforced? If there is an amendment to the lease, how is that enforceable as an amendment to the lease, and therefore the lease is deemed to be amended? And the third alternative, which I think my learned friend is still advancing, is that it is of itself an enforceable standalone agreement, i.e. the email itself is a standalone agreement. So I'm going to deal with those three as part of the first limb of immediate judgment. Then I'll go on to deal with the other compelling reason later on. So, but what I think is a good exercise is if we just look at the emails that are relevant, and actually perhaps even the lease agreement itself. So can I take Your Excellency to the lease agreement, which is that. Sorry, were you going to say something?
Yeah, Mr. Kashdala, are you referring to the case bundle or your PDF bundle?
Case. Well, I think
Case
they're
bundle.
the same, maybe, but I think it's page 618.
Bear with me.
Yeah, 618.
You said 618, right?
Correct. Yes, it should be the first page of the lease agreement.
Right, it is.
Right. So the first point number one is we have the Collection Club Restaurant Limited, and that's D1, and D2 and D3, Mr. Laurent and Mr. Hugo, as what's generally collectively referred to as the second tenant, but they are D2 and D3. And then we need to look at clause 5 of the agreement, which is page, I think it's the next page, 619.
Yes, right.
I'm just going to read this out because we have to be careful here. The tenant shall submit a copy of its trade license to the landlord once issued, but not later than 3 months. The tenant shall be obliged to provide the landlord with post-dated checks upon signing the agreement at the tape, and then it deals with the checks. We can stop there. Whilst there is a reference to the tenant, it's obvious that that must be D1 because the trade license belongs to the corporate, not to D2 and D3. They can't have trade licenses. But the point here is that the trade license must be issued and no later than 3 months and must be submitted. So the tenant shall submit a copy of its trade license. That is an express condition contained within the signed and executed lease agreement. So I started there because we need to now look at the emails themselves.
It is striking you have not referred to tenant, I mean, in the plural with S instead in singular portion.
Well, striking or not, the reality is that sometimes we've seen tenants and sometimes within tenant, but I don't think it's inconsistent because the tenant that needs to provide the commercial license has to be D1. I don't think that's a problem, and I don't think that makes any difference to the submission I'm making. And I respectfully submit that it's not relevant here. It will become relevant later. But can I take you to the email because I think that will give it some context that we need to look at, and that's page 609, I think it was.
Please.
610. This is the email from Mr. Wazine. Mr. Laurent, maybe even, I should say.
Yeah, Laurent.
It's okay,
Yeah.
Laurent Hussein.
And so what he says is that it's clear that they've had discussions and he's reviewed the new version of the agreement. And then he says, we would like to highlight and agree that once the UAE company license is issued and provided within the time frame mentioned, which is not later than 3 months, so an acceptance that there needs to be a submission and a provision of the license, then an addendum to the lease agreement should be added. So I stress that because I think what my learned friend does is she glosses over this point. and is frankly missing the point, because this email is, all it's saying is, or what the proposal is, that the parties should enter into an addendum and then therefore be added. This can't be of itself a contract, and it can't of itself imply an obligation. This email, all it's saying is, once this condition is fulfilled, can we agree to enter into an addendum? That's all this is saying.
So in basic, Ms. Khushda, you saying what the defendant trying to label the correspondence as a agreement itself, where you saying it's an arrangement to a change of the current agreement, like the addendums?
Well, actually, I'm not. I think the defendant is trying to label this either as an implied obligation into the lease, or alternatively is saying this is amending the lease, or my learned friend is saying this of itself is an enforceable agreement of itself. But what I'm saying is, what I'm inviting the court to conclude is all this is an agreement to enter into an addendum. That's it, or at least it's the proposal at this stage. Then
you call it a discussion or agreement?
Well, actually, I think this is probably a discussion, but at its worst case, at its highest for the defendant, it's an agreement to agree. It's an agreement to eventually agree. Because what it says is an addendum to the lease agreement should be added once the condition is fulfilled. But that necessarily implies, well, actually, I think it's pretty obvious that means everyone must collaborate and enter into an addendum, as you would expect. It's not a unilateral obligation that the claimant provides an addendum that is executed by the claimant only. That makes no sense. And that's the problem with the defendant's argument, is that they are imposing a unilateral obligation on the claimant only, completely ignoring, well, my learned friend shakes her head, but that is exactly what she's saying. She's completely ignoring the fact that in order to enter into an addendum, you need all parties.
Mr. Dre, may I advise you, please, to control your body language and be calm?
The reality is that all parties have to enter into an addendum consensually, and there is absolutely, and I'll come on to develop this later, but there is no evidence of, for example, either the D2 and D3 following up later saying, hey, what's going on? Can we enter into this addendum? There's none of that, even on her own case. As she said, this is it. So just going through the emails, if we go back up to page 609, we've got an email from Louay Al-Sabuni saying, yes, we confirm the below, please arrange to sign the lease agreement. What does that mean? We agreed to your proposal, and now please sign the lease agreement. There is no suggestion at all that the defendants, we know this for a fact, that there should be an amendment or an insertion of a clause into the lease agreement itself. My learned friend refers to her clients as business people. These two business people didn't say, hey, by the way, can we actually insert this into the agreement as an enforceable express condition? In fact, the agreement itself is left totally unamended. And then the following email is, please find accordingly the lease signed. That's actually why I say these are negotiations. That's my primary position. But I say it at its worst, and I don't push this as my primary position, obviously, but at its worst, it's just an agreement to eventually agree. That's it. Then what we have in terms of the correspondence, which is pertinent to look into, is the email from the claimant at page 611, dated.
So let's pause here, Skoshdel, and ask you again about the email of the September 6th. When you said attach the signed lease agreement as you requested. Yeah,
that's the one I want to look at. So can I just
your client have signed that addendum lease, isn't it, and sent it to the other party?
No, that's the lease agreement. So what happens
No,
is
the original lease agreement.
correct. That's right.
Oh, the
So
first
what
one,
happens?
yeah. Oh.
Because there isn't an addendum. That's the ultimate point. There is actually no addendum to the lease agreement. So what happens is, if we just following it through, on the 17th of August, Mr. Bouzine emails Mr. Al-Sabuni to say, please find accordingly the lease signed. So we have the suggestion to enter into an addendum, the agreement to do that upon fulfillment of the condition, and then the defendants say, here's the lease that you wanted and we've signed it. After that, on the 6th of September, as you've correctly identified, is the claimant saying, well, here's the countersigned lease agreement. That's the order of events. The other fact that we need to look at now, I think, is the letter that Madhani friend referred to at page 60. There's the letter of the 24th of June 2024, which is at page 589 of the bundle. This is the termination agreement. Sorry, the termination letter. Although I've said page 589, but I may be wrong about that. Let me just check my page references. I've got the wrong page reference.
616, I think, if I may just say.
616. Thank you so much.
Sure.
Now, what my friend says is 24th of June 2024, we've got a letter which is a notice of termination, where there's a reference to the lease agreement entered into by MAG and D1. I'm just going to call them D1 because it's easier that way. And so D1 purported to terminate the lease agreement. Then what my learned friend says is, well, look at the letter from Mayor Brown, because what Mayor Brown is doing is saying, well, in fact, the claimant is going to terminate the lease agreement. That's at page 635. What my learned friend doesn't tell you is that this letter is responsive to the letter from White and Case on the 24th of June, as very clearly says, we act for the landlord, we refer to the lease, and your letter dated 24th of June addressed to our client. We acknowledge your letter which sought to terminate the lease. So that letter is responsive and therefore doesn't take my learned friend's case any further forward, and is in fact it's not correct for my learned friend to say, well, this of itself is damaging evidence that Mayor Brown is somehow saying that, well, this is only a termination by D1. No, this is a responsive letter to D1's termination letter. But what I say is damaging to my own friend's case, which she's tried to again gloss over, is the very fact that it's part of her pleaded case at page 67, paragraph 24. So page 67, paragraph 24 of the amended defense, verified by a statement of truth, is that all three defendants notified the landlord with a termination letter. So the election that D2 and D3 have taken through the amended defense is that they were part of that termination letter. That is what they've elected to plead with a statement of truth. Now, if my learned friend wants to say, well, that's an error, then the problem is that she's stuck with the amended pleading as it is, and she'll either have to amend, or there'll need to be evidence as to what the error was. Anyway, what I'm saying is, for the purposes of an immediate judgment application, she's stuck with her own amended pleading. where where D2 and D3 voluntarily have piggybacked off that letter to terminate the lease, which means they must have been parties to the lease agreement. That's the ultimate point here, that they were clearly parties, and that's why they elected to terminate. There is a contradiction, which is at page 582 of the bundle, at paragraph 25 of the defendant's written application, which is Madhani Friend's legal submissions, where she says that in fact, following a series of unsuccessful exchanges between the claimant and all three defendants, White and Case, who were advising the defendants on the implementation of the Bright project, informing MAG that the first defendant intended to terminate. The fundamental problem with Madhani Friend's case is that there are so many inherent consistencies with her position. Sometimes it's the defendants, sometimes it's the defendant, sometimes it's the first defendant. It's frankly all over the place. But this document that we're looking at now is a legal submission. It's not a statement of truth. It's not a statement of case. So there isn't a statement of truth. It's not evidence. It's just a submission on the facts and the law. But the amended defense does have evidential value because D2 and D3 can be cross-examined at trial as to the contents of a statement of case. So before the 20, so just to close this all off. So we've got the correspondence in August 2023. Then we have the signing of the lease agreement by the defendants, all three. Then we've got the claimant's countersigning. This is the order. This is how it goes. Then we've got nothing happening in relation to this topic until what my learned friend says is the 24th of June 2024 letter, so nearly just under a year later, where she now says, well, D1 terminated. So nothing happens. There is no correspondence to say, hey, we need that addendum after all. Nothing at all. And more importantly than all of this is that my learned friend doesn't even seek declaratory relief, a declaration that D2 and D3 were never, or either never a party to the agreement, as it seems to be that she's suggesting, or were effectively removed from the agreement for the reasons that she's provided. There isn't that count. She hasn't brought a counterclaim at all. I accept that there is a reference in the amended defense in the relief section to a declaration. That's at page 82 of the bundle. So I accept that the defendants want the court to declare that the lease agreement was not properly amended and cannot be enforced against the defendant, but that's of itself so poorly drafted. That's got its own problems, frankly, because it's not properly amended. Well, there's no particularization of that, and cannot be enforced against the defendant. Well, which defendant? And in any event, this is not a part of a counterclaim. She needs to have sought declaratory relief, and I'm going to make that good with some law. So can I take you, please, to I think it's in my skeleton argument. In fact, it might be easy to look at it there. Yeah, I think we can start with DIFC contract laws. I don't know if you've got if my bundle of authorities have made its way to you. There should be a separate bundle of authorities from the claimant.
Right. What page are you referring to?
Well, tab 9. So that's the contract law, which starts on page the PDF page 213.
The PDF labeled claimant legal authorities, yeah?
Yeah. Actually, let's
Yeah.
do it. I think maybe the
What's-
best, actually, the easiest way to do it.
Page number?
Well, let me take
Yeah,
another
please.
way. I'll give you the page 265.
Yeah, this is
if you're on a
law of damages and remedy.
Yeah, law of damages and remedies, because clearly my learned friend is saying there's some sort of failure to perform. The failure to perform being the amendment or the removal of D2 and D3. And given that she expressly says in her amended defense that she wanted a declaration, then what she should be pleading is for a specific remedy as part of the counterclaim, because Article 37 says if the court may make binding declarations of points of facts. I mean, these are we know this as a matter of routine, but I'm just making these references for the sake of completeness. So what she should have sought is specifically make reference to Article 37 of the Law of Damages and Remedies to say that she wants this declaration as part of a counterclaim. But she doesn't do that. So that's a bit of the factual background that I wanted to cover again. I don't know if Your Excellency has any particular questions on the facts, but I'm going to deal with some more of the submissions that my learned friend made.
Please move
in
on.
support of my submissions. Bearing in mind that I think one of the points that we just need to bear in mind before delving into the how the application that my learned friend meets the test. We haven't actually heard any evidence, or sorry, we haven't received any evidence by way of witness statement from either D2 or D3 saying that for them this was a quote unquote done deal. There is no evidence to that effect, and what my learned friend is saying, she's giving evidence from the bar, and that's not permissible. So you can disregard that, whatever my learned friend says about that. If that's what their position is, they need to make that good with evidence, not just make it as part of oral statements. Notwithstanding that, there is a serious evidential gap where if for them this was a done deal, then there would have been some protestation at least through emails, which I've already made that point already. But what we do have is the second witness statement of Hugo Valla, which was submitted as part of the defense, the original defense, I think. And we've got his third witness statement as well. The second witness statement doesn't say much other than, broadly speaking, just mentioning the email correspondence. So there is reference to that in his second witness statement. But the third witness statement makes reference to the no objection certificates, and my learned friend makes a big play on this. So can I take you to the no objection certificates at page 753 bundle? Well, let's look at 751 for the sake of completeness. Let's look at 751. That's the witness statement of Hugo Valla. So he says he finds 2 NOCs as part of document production. And I don't know why my learned friend expresses so much surprise that the claimants didn't produce this. The claimant is only obliged to produce documents that it relies on as part of its case. It's not the English style disclosure where you have to declare to the other side that they've got some documents which may or may not undermine its case. So, and in any event, if this was so significant, substantial for my learned friend, then she should have produced it, not go undertake a search as part of the request to produce. Anyway, that point aside, he says at paragraph 6 that we found 2 NOCs for alcohol and shisha provided by the claimant. And these are exhibited and found at pages 753 and 754. My learned friend says, aha, this is the silver bullet. This shows that D1 is the only true tenant. But I'm afraid to say that my learned friend completely misses the point, because an NOC is literally a no objection certificate for anyone, in this particular case, the restaurant, the D1, to do something without any objection. The context here is that there is no objection for D1 to serve alcohol. I sincerely hope that my learned friend is not suggesting that D2 and D3 should have had NOCs to serve alcohol if they were the true tenants. I mean, that's an absurdity. Of course, D1 is going to have the NOC in its favor because only D1 is licensed to serve alcohol, not D2 and D3. And in relation to the second NOC, smoking shisha, page 754, the same principle applies. The no objection certificate can only be in respect of D1 to have smoking shisha in the unit. It's got nothing to do with D2 and D3 individually. This is an absurdity in my respectful submission that somehow NOCs can now prove at this stage that the D1 is the only tenant. So I say you can dismiss that submission from my learned friend with ease. So I want to now look at the three ways that my learned friend says that there was a failure to perform by the claimant. Because what I think we also need to distinguish is there isn't the contract law doesn't actually say there's a breach of contract. It's actually a failure to perform. So what I think she first says is, by virtue of Article 57 of the DIFC contract law, there is an implied obligation and therefore a failure to perform that implied obligation. So if we just look at the contract law, I'll give you a page reference. That's page 227 of the claimants authorities bundle.
Right.
Yeah. So what I think she's saying is there is an implied obligation by virtue of the emails that there would be, she says, an agreement on the claimant, but I don't think she can sincerely make that in good faith. The best that she can say is that the parties would agree to an addendum, and we've seen the emails about that. So I suggest that shouldn't be too difficult to conclude. But then applying Article 57, what she must be saying is that the implied obligation arises from I'm slightly at a loss, but I suppose she must be saying good faith and fair dealing, and maybe even reasonableness. But I don't think my learned friend developed this properly. I think the fundamental problem is that you can't imply an obligation from that email that fits the criteria of Article 57. Because because if you've got an email that says we will do X once you fulfill condition A, that doesn't fit the criteria of Article 57 because you can only have an implied obligation from the nature and the purpose of the contract, the practices established between the parties and usages, good faith and fair dealing, and reasonableness. But the problem with her, if she is advancing a good faith argument, is that you have to perform your obligations in good faith, and that's why you've got the implied obligation of good faith. So you are performing your express obligations in good faith. But we've got the lease agreement, which was signed after those negotiations. So claimant is performing its obligations in good faith, pursuant to the lease agreement. If there were even an agreement to remove or an addendum, and the claimant did not remove D2 and D3 after the parties entered into an addendum, then there's an express failure to perform. But we don't have an addendum. There is a serious problem with the defendant's case, which is they don't have an addendum, and therefore you can't get over the hurdle of, well, we don't have an addendum, therefore you breached the contract in some way. I think that's where my learned friend's case is fundamentally falling apart. If the defendants were continuously saying, hey, by the way, we had that agreement from 17th of August by emails, you're not entering into an addendum, and there's perhaps even an act of prevention, then that's one thing, but that's not the case. So I'm still at a loss as to how Article 57 applies. But I say that with respect, I think my learned friend's position on this is rather confused and muddled. And in fact, Article 57 doesn't imply any such obligation. But even in any event, there are submissions I'm going to make on the conditions or the condition precedent in order to remove D2 and D3. I'll come on to that in a moment. So let me just look at paragraph. So looking at paragraphs 43 of my Skepton argument. My own friend hasn't even pleaded in her amended defense the legal basis on which there is an implied obligation. What she's now saying as part of this immediate judgment application is that there was an implied obligation. She hasn't even pleaded it. So in fact, it's not part of her case, her pleaded case. What she says is this happened, that happened, except X, Y, and Z. She doesn't say how there is an implied obligation as part of her pleading. I've already made submissions that there can't realistically be any suggestion that email correspondence implies an obligation only on the claimant to enter into an addendum agreement. That's an unsustainable position. What I say is that there is at best only an acceptance, a joining of minds, if you like, that at some point in the future, if the condition is fulfilled, we'll enter into an addendum. But we collectively will enter into an addendum. So then the next argument that my learned friend puts forward is there was an express and enforceable agreement that the parties will enter into an addendum, paragraph 48 of my Skepton argument. And she also, I think she similarly relies on Article 57. And I say this is a confusing plea because she seems to be suggesting that there was an express obligation to amend the lease agreement, but that created an implied obligation. And that's from her, that's taken from her her submissions. But that obviously has inherent flaws and inconsistencies. But I think the ultimate point, or the ultimate takeaway here, is that an agreement to agree, which I referred to earlier, is too uncertain to be enforceable. And I made reference to the case of Walford and others and Miles. That's at page 112 of the bundle. I say the bundle, I meant the claimant's legal authorities. So 112 of the claimant's legal authorities bundle. Next to letter D.
Yeah, Lord Doctor.
It should begin, there is a suggestion. I don't know if Your Excellency sees that.
Okay, just to be accurate, the page number is 113.
112, sorry.
Excellent.
Next to letter D.
Yeah, there is suggestion in such cases.
Suggestion,
yes.
correct. So it's making reference to the Scandinavian trading tanker case, that the entire effect of any agreement to negotiate is illusory. If there is no consideration, this may be the case. If consideration is identified, there is no principle which will deprive all such agreements of effect if there are in fact agreements as to the conduct of negotiations rather than a misnamed agreement to agree. In other cases, the nature of the obligation may be too uncertain to be enforceable. In the present case, however, the obligations in respect of negotiation were subordinate to the principal object of the agreement, which was to exclude the auditors. And then it goes on to look at enforceable agreements to negotiate, how it's not offensive to English contract law, but we now have to look at page 119 to find to reach the conclusion that I say we need to reach. So page 119.
Right.
What Lord Ackner says at next to letter C is, while accepting that an agreement to agree is not an enforceable contract, the Court of Appeal appears to have proceeded, so the Court of Appeal hearing the case before, is not an enforceable contract. The Court of Appeal appears to have proceeded on the basis that an agreement to negotiate in good faith is synonymous with an agreement to use best endeavours, and as the latter is enforceable, so is the former. But this appears to me with respect to be an unsustainable proposition. So I emphasize the following sentence. The reason why an agreement to negotiate, like an agreement to agree, is unenforceable is simply because it lacks the necessary certainty. The same does not apply to an agreement to use best endeavours. So it's similar to good faith, but perhaps not quite the same. But an agreement to use best endeavours to perform an obligation is different to an agreement to negotiate or an agreement to agree. Because when one has an agreement to use best endeavours, you have certainty as to which obligation they're ultimately trying to achieve or to realise. So use your best endeavours to fulfil clause X of a contract, for example. But the problem with an agreement to agree and an agreement to negotiate is it's so speculative as to when that can happen, whether the parties even want to agree in the future to do something different, or it's too hypothetical. That's the point. It's too uncertain. So if it's too uncertain, then it can't be enforced. And when D2 and D3 say, well, we've got a clear express agreement as a result of the emails, that's just wrong. The best they've got is an agreement to agree, but the reality is that's no different to an agreement to negotiate. It's all the same. It's too uncertain. And as the facts of themselves show, neither defendants 2 or 3 were that bothered to not even say, well, can we have that addendum after all? Because positions change. People, commercial considerations change, or people don't really are not that bothered. For example, later on, times move on. So the point is that the point I make here is where my learned friend says there was an express and enforceable agreement to enter into an addendum, that's not sustainable in law, because an agreement to agree is too uncertain and therefore cannot be enforced. Another question that my learned friend needs to address is, well, how did the claimant even fail to perform the obligation? So looking at paragraphs 52 onwards, how did the claimant even fail to perform? If there is a contractual obligation, even if there is, how did they fail to perform their obligation? The only way that the defendants could succeed is if there is an obligation on the claimant and the claimant then failed to perform that obligation. If the email chains create an obligation, at best, it is on all 4, meaning the claimant, D1, D2, and D3. Putting it another way, it's arguable perhaps even all of them fail to perform. But what my learned friend needs to persuade you is that only the claimant failed to perform the obligation, which must necessarily imply that D2 and D3 didn't, but there's no evidence of that. It wasn't even thought about. I mean, she makes the point that they're business people, is a done deal, etc. Obviously no evidence of that, but if anything, it seems like everyone pretty much forgot about it, and D2 and D3 were not bothered enough to say, hey, by the way, claimant, we'd like an addendum, as you said you would agree to in your email of the 17th of August. None of that. Now, I want to weave in relation to this point, and what my known friend says about the requests to produce, and she specifically made reference to request 13. So she says it's irrelevant, and she made submissions to you about that. The requests to produce is at page 734 of the bundle, of the main bundle. So what you should see is document production request number 13.
Right.
Does Your Excellency have that?
I do.
Okay, perfect. So what was requested was all the internal communications between the defendants, so WhatsApp, SMS, etc., between the 15th of August, when they signed the lease, and the 24th of June, which is when they purportedly terminated the lease, specifically in relation to the purported amendment to the lease. So putting it another way, putting it very simply, what the claimants want to know is, what did you say to each other? How important was this point for you about the addendum? Because if it really was, you might even expect to see messages between D2 and D3 saying, hey, by the way, whatever happened to that addendum, for example? So my known friend doesn't see the relevance of it. The relevance is that if it was such a big deal, at the very, very least, D2 and D3 would say to each other, whatever happened to that addendum? But it clearly wasn't important for them because my known friend says, firstly, there aren't any documents. She says, does not exist. But secondly, she says that the only communications regarding the amended tenancy is with the claimant. So this is it. The emails from the 17th of August is as good as it gets for these defendants. And they can't do better than that. So her position, or their position, I should say, that they don't have any documentation supports the claimant's case. In fact, that there is nothing in this point whatsoever. D2, D3 didn't communicate between themselves about this point, and then didn't raise the point with the claimant either, that this was a forgotten about thing. And so it's a non-issue. And yet my own friend insists that there is a breach of an obligation of contract. What I invite you to conclude is that there is nothing in their possession, custody, or control that can demonstrate any attempt to comply with, any attempt to amend the lease agreement. There is nothing that's going to assist you. Now, when the response came to, or when the evidence and answer came to the immediate judgment application, disclosure was not yet complied with at that point. My own friend made an application to extend time for compliance with disclosure, and she suggested the 6th of November initially. But given that there wasn't a conclusion reached on disclosure, we weren't to know really, in reality, whether anything was coming or not. But I mean, we've already seen that D2 and D3 can find documents, for example, the NOCs. So there is still a question mark as to what can happen in the future. But anyway, taking this document at face value, if nothing is coming, and I accept what my known friend has said that there is nothing coming, then there is no, therefore there is not going to be any further evidence on this. Then all we can do is go by the emails of the 17th of August and the very fact that the lease agreement was signed, as you've already seen.
Mr. Kushner, if you allow me, I would like to ask you a very simple and direct questions.
Yeah.
Did you deny the fact that your client have received the license of D1 around its issuance time?
I think we did. I'm just looking at the amended reply. I certainly remember. I certainly know that it's been put to that it was denied as part of the 5th witness statement of Gerard Moore, which was the evidence in answer to the immediate judgment application. But I'm just going to check the amended reply as a pleading.
I will ask you later, Mr. Drain, when the license been communicated according to your own statement to the claimant. Go on, Mr. Kushner.
Let me show you where Mr. Gerard Moore, in the 5th witness statement in his 5th witness statement, deals with this point. Or the other thing that I could do, and if those instructing me are hearing me, if they can find that reference, then I will carry on, and then I can give you those references later.
Anytime.
I certainly remember that was dealt with, and I'm going to come on to deal with this later because I think I've just got messages. Yeah, it's paragraph 35. Okay, so I'll give you the page reference. That's page 652 of the bundle. Yeah. Paragraph 35. The defendants have failed to submit any evidence of them having satisfied all conditions for the first defendant to become solely liable under the lease. Sec 36. No evidence of the defendants having provided the first defendant's commercial license to the claimant. So, for example, an email or something like that. There is no evidence of that whatsoever. Sorry, I'm just going to read on just to make sure we covered this point in full. Yeah, Mr. Moore makes the point that I was making earlier, which is it was clearly an important aspect of the alleged agreement because otherwise Mr. Bouzzine would not have expressed this condition in his email. So there is a total lack of evidence on this. We can look at the commercial we can look at the commercial license, but I know that, and another friend referred to the commercial license where the issue date was backdated, but we don't have actually any actual evidence of when it was issued. So nothing, for example, an email from the DIFC authority saying, but here, please find attached your license, or a portal, or sometimes you can go, some free zones, I can't remember that DIFC is one of these, but some free zones have a portal and you can go on the portal and it shows you the issue date on the portal itself. And it's particularly important where if the issue date is going to be backdated, you still need to know when the DIFC authority actually issued it on the actual date. And there is no evidence of that. Secondly, whether it's
so the license is, in its own doesn't have an issuing date, like
no, it has
because it has issuing and expiry. This is, I think, the usual licensing matrix.
Of course it does,
yeah.
But that's not the point. I think we should.
You mean that's what's not communicated to your client?
There are two things. One is that, but let me go to the license 631 of the bundle. The 631 is the commercial license. I don't know if you have that. Can I just ask, are you using the...
it says issue date 6th of June 23.
But this was, but the lease agreement was entered into in August. So what's happened is there was a backdating of the issue date. Well, that's what it appears, because the lease agreement, when it was entered into, what says when the commercial license is issued, we will submit it. So prima facie, at the time of entering into the lease agreement, the commercial license didn't exist, which means it must have been backdated.
Yeah, and I think that's rational because they won't produce a commercial license without having a premises within the DFCs, isn't it?
Well, that's why these two the shareholders were included in the lease agreement, because the risk that was the exposure to the claimant was, one, it's not going to get any rental payment from an entity that doesn't exist, but two, it was unclear whether in fact we know because there was within the email itself, Mr. Laurent said that when the commercial license is issued, we will let's enter into the addendum. So it's clear that at the point at which the lease agreement was entered into, the commercial license didn't exist.
How can we read that with the tenancy agreement registration like that, 1st of September 23?
Which one, sorry? Oh yeah.
The next
first
document, we
yeah.
can see the registration of the tenancy agreement was like issued by the DFC 1st of September. So is it more likely that so the contract is not being issued before, not before the registration date of the what's called tenancy information?
If I understood your question, I think you're saying because of the property, the registration certificate, then it's more likely that the commercial license was issued before September.
After 1st of September 23. That's what I'm saying.
I think the fundamental point here is that there are too many ifs, buts, and maybes. There are too many unknowns. We don't know because I think you can probably safely conclude that the lease agreement, when it was entered into on the 15th of August, commercial license didn't exist. Otherwise, why would they say, when we get the commercial license, please remove D2 and D3, or we'll enter into an addendum to remove D2 and D3. It didn't exist. Otherwise, and in fact, had it existed, you wouldn't even had D2 and D3 as parties to the lease agreement. So the most you can probably conclude here is that at some point after August, the actual commercial license was in fact produced. Let's put it that way. It was created. When it was created, I don't think we can say for certain when it was created, because it's also not because even if the registration certificate, the tenancy registration certificate is dated the 1st of September, just as the commercial license can be backdated, it's also conceivable that this could be backdated. It's just all I'm saying is, and I'm not saying, and let me be clear, I'm not saying anything with any particular certainty other than the commercial license didn't exist at the time the lease agreement was entered into when it was executed. I think that we can probably conclude with, if not 100% certainty.
To the extent it was not in the claimant custody, isn't it?
I'm not sure if we'd even need to go that low. I think we can. Let's go back to the emails because and maybe even the lease agreement, because the lease agreement is I think it was clause 5. Yeah, page 619. So 619. So clause 5 says the tenant shall submit a copy of his trade license to the landlord once issued. So it's an express term of the lease agreement that it hasn't, only once it's been issued, then it will be submitted. So at that point, it wasn't. If we look at the emails again, page 610. So page 610, we've got the email of the 16th of August, a day after the date of the lease agreement. So it's clearly there's a lot of backdating going on in this case. But as of the 16th of August, Mr. Bouzine says, we would like to highlight and agree that once the UAE company license is issued and provided within the time frame, etc., etc. So even as of the 16th of August, it's still not been issued. And it was pleaded by my own friend in, I think it was in her second witness. It was in the evidence in support of the immediate judgment application. She herself said that it was backdated. It's in her witness statement. Yeah, so paragraph 60, page 588 of the bundle. So page 588, please.
588, yes.
Let's start with paragraph 14 once it loads for you.
This is Mr. Ray witness statement?
Correct. This was the witness statement in support of the immediate judgment application.
Right.
So paragraph 14, 15th of August, first defendant with Bouzine and Vala entered into a lease agreement. Fine. Paragraph 15, the emails. We've already been through it. Paragraph 16, the license was granted in August 2023 and backdated to a date before the lease agreement was signed. We've seen the commercial license. That must be a reference to June 2023. What we're missing is the evidence to support her statement that the license was granted in August 2023. That's a statement without any evidence at all. There is no supportive evidence provided by her. She later changes that date. She later says it was September. Yeah, paragraph 42, page 591.
Yes, I'm in 591.
Paragraph 42.
The
Stray
4th
says,
of September.
yeah. On the 4th of September. So now it's changed from August to September, and we've got a specific date. 4th of September 2023, the license was granted backdate, and then it was, she says, backdated to 6th of June. So if we go back to the commercial license at page 631,
Right.
if we've got the commercial license, if you may see the QR code in the bottom at the bottom left-hand side of the screen.
I do. Yes, I do. Yeah.
And you'll see a date, 4th of September 2023. It's very small.
Right, yes.
So that must be what my learned friend is referring to, although I respectfully submit she can't actually give this evidence because she's not a witness of fact. So there is that, so I ask you to just bear that in mind, and perhaps going forward, that's something to note. But anyway, so we've got, I've taken you through the evidence that my learned friend gives. I've taken you to the commercial license where we can see there's backdating. We've got it says date 4th of September 2023. And then the property tenancy information registration certificate at 632 says that the date is the 1st of September 2023, which is backdated. So I think what we're getting at, the ultimate point here is there are so many moving parts. You need evidence. You need evidence by way of witness statements from D2 and D3, explaining all of this, everything that we've just gone through now, and the other missing part of the jigsaw is how they communicated that to the claimant, because the other condition was that it would be submitted to the claimant, and that's also missing from this immediate judgment application.
Right.
Can I just, yeah. So that was to answer Your Excellency's direct question to me. But can I just say this, that whilst all of this is clearly important, the ultimate point is a cause of action lies with the underlying agreement, contract, not with the commercial license, as in of itself, not with the registration certificate. So even if the registration certificate says D1 is the tenant, for example, which it does, that of itself doesn't mean that the cause of action lies against D1 only, because that's not the contract. The contract is the lease agreement. And if the lease agreement is not amended mutually, then D2 and D3 remained bound by that agreement. My learned friend wants to say, well, the 24th of June 2024 letter was only on behalf of D1, then strictly speaking, D2 and D3 didn't purport to terminate the lease agreement, if that's the position she wants to take. And if she wants to go further to then say, well, Mayor Brown have now, in the subsequent letter, which the date escapes me, but you know the one I'm referring to, only purported to terminate against D1, then somehow D2 and D3 are still party to the lease agreement. That's what that's how problematic her case is. Now, at paragraph 61 of my skeleton argument, I wanted to demonstrate to Your Excellency that even if there is a failure to perform on the part of the claimant, its obligation, as my learned friend puts it, then there are mixed questions of fact and law as to non-performance. And if we look at page 232 of the claimant's authorities bundle,
You just said 212?
232, please.
232. Right.
So this Article 77 defines what non-performance is. And non-performance is a failure by a party to perform any one or more of its obligations under the contract. Excuse me. So if we look at Article 81, which is the same page. So in the case of non-performance, the aggrieved party, which in this case will be D2 and D3, may by notice to the other party allow an additional period of time for performance. And then we've got some conditions as to what happens during the additional period. And what happens if there's a delay of non-performance, which is not fundamental. So that's Articles 81, 2 and 3. But the point here is that if we are talking about non-performance, as opposed to fundamental non-performance, there are some preconditions to termination. And there's, well, that's not been dealt with at all by D2 and D3 in this application. And to ignore it is a problem, because D2 and D3 are saying that the claimant has failed to perform its obligation. So they need to also demonstrate how they have complied with the DIFC contract law. Now, if they're saying, in fact, this is fundamental non-performance, that's paragraph 8, Article 86 of the contract. Article 86 of the DIFC contract law, page 233, the next page. So if they're saying that this is fundamental non-performance, they were entitled to terminate the contract where the failure of the other party to perform an obligation under the contract amounts to fundamental non-performance. What does that mean? Look at the subsequent article, Article 86.2. In determining whether a failure to perform an obligation amounts to a fundamental non-performance, regard shall be had, in particular, to whether the non-performance substantially deprives the aggrieved party of what it was entitled to expect under the contract. Strict compliance with the obligation which has not been performed is of the essence. Whether non-performance is intentional or reckless, non-performance gives the aggrieved party reason to believe that it cannot rely on the other party's future performance. And Article 86.3 says in the case of delay, the aggrieved party may also terminate the contract if the other party fails to perform before the time allowed under Article 81 has expired. The ultimate point here is the defendants haven't dealt with this at all. And they keep hammering home the point to you that somehow the claimant has failed to perform. And they haven't dealt with it. But these are the types of issues that have to be dealt with at trial. You can't deal with them now. It's too premature. That's what our ultimate point is here. There are too many open questions that haven't been answered by the defendants. I've already made the point that there has not been any attempt by D2 and D3 to terminate the lease based on any fundamental non-performance to enter into an addendum. That's the ultimate point. There has not been a termination notice sent by D2 and D3 to say, by the way, you didn't enter into an addendum. You didn't remove D2 and D3, therefore we're terminating. That didn't happen. And there are other estoppel issues that arise under Article 84D, which is again 233. And where a party who owes an obligation other than one to pay money doesn't not perform, the other party may require performance. So this is not an obligation to pay money, because the obligation is to remove D2 and D3 or to enter into the addendum. So this would apply. The other party may require performance unless performance is impossible, which it wasn't. Performance or where relevant enforcement is unreasonably burdensome, which it wasn't. Performance is of an exclusively personal character, it wasn't. Or the party entitled to performance does not require performance within a reasonable period of time after it has, or ought to have, become aware of the non-performance. So that gap in time from, let's say, September, to be very generous to the defendants, from September when the countersigned lease agreement is sent to the defendants until the 24th of June 2024 letter from White and Case, D2 and D3 require performance within a reasonable period of time. They've never required performance until this immediate judgment application, or these proceedings, let's say. And that's fatal to the defendant's case. The other argument I want to deal with is that somehow the email amends the lease. So if we look at paragraph 18 of Madhani Fretton's witness statement, page 58. Sorry, not 589. Yeah. page 743 of the bundle.
Yes, I mean.
Paragraph 18, the parties executed the amendment in writing by exchange of email. And this is perhaps best evidence as only the first defendant is listed. And then she makes reference to the NOCs. So she says that the parties executed the amendment in writing. But what is she really saying? She's saying the lease is entered into and it was signed by her clients. And then there is an amendment in writing, which doesn't, Frank, that's a bizarre submission, because the agreement was to enter into a future addendum came before the defendants returned the lease agreement, supposedly. So that doesn't make sense. I've dealt with the no objection certificate, so I'm not going to take you through it again. I've dealt with the letter. So looking at paragraph 81 of my skeleton argument, I say that the claim that there is more than a realistic prospect of the claimant succeeding against D2 and D3. The harsh reality for D2 and D3 is that they are parties to the lease agreement. The email only amounts to an agreement to agree upon the fulfillment of certain conditions which cannot be proven to have been fulfilled, and in any event is too uncertain to be enforceable. And that's not a fanciful prospect, that is a realistic, or more than realistic prospect, we would say. Now, the point about my learned friend makes about, the point that my learned friend raises about guarantors. Firstly, I noted that my learned friend made reference to guarantors within her own skeleton argument, so I don't know why she's so confused by our reference to it. But the very simple point here is, well, the court may ask, why would two individuals be party to, in effect, a retail lease agreement? Because it wasn't residential; it was a retail lease agreement. And if we look at the lease agreement at page 20 of the bundle, sorry, I'm losing my voice, so I keep coughing. So page 20 of the bundle, and we've got the lease agreement between the claimant and the previous retail tenant. That was Red Rose Lounge. But what you don't have there are two individual or shareholders named as tenants. What we do have in this case with the collection club is the shareholders named as tenants. So that would raise a question with the court, a reasonable question. Why were these two individuals named? Again, an issue that has to be dealt with at trial. Why were they even included? Now, we say that you can conclude, well, at least it's open to conclusion, that they were guarantors. Because why? Because there wasn't a commercial license. Because there was no guarantee that it was going to be able to trade. If it wasn't going to trade, it wouldn't be able to pay the rent. If it wasn't going to pay the rent, the landlord has already terminated a previous agreement with Red Rose Lounge out of pocket, and therefore needs to have some sort of guarantee to be able to recover its money. If my own friend wants to say, well, there are rules about guarantee agreements, etc., then she's going to, there are many cases where people just don't comply with formalities.
Yeah, but Mr. Kushdel, I mean, they guarantee what? If you said if the D1 is a dormant company, it did not exist legally, so it's not, it can't bear any kind of liability, then they guarantee what? So I think there's going to be a lot of questions related to yeah.
Well, the rent. It could, well, I should say, I'm not saying with any definitive, that you can draw any definitive conclusions. That's not what I'm saying. What I'm saying is that there is a reasonable question from the court. Why would D1, why would the claimant enter into a lease agreement with a company that doesn't exist? And why would it name its shareholders, or at that point, perhaps even proposed shareholders.
Or directors.
These are questions that, sorry?
Or directors.
Okay, well, even directors. But why would they even be named in the lease agreement? That's all I'm saying is that that's a legitimate question. It's possible that they were to be effectively guarantors. That's a possible conclusion, and you don't need to be satisfied that that is the conclusion. You just need to be satisfied if it's possible and there's a realistic possibility of that. You're going to need to hear evidence on it. That's all we're saying, because the converse that my learned friend wants to impress upon you is that these two, she actually doesn't even provide a full explanation for why they were named, and there isn't any evidence from them as to why they were named. So all we can do is just draw some conclusions based on, or draw inferences based on the facts we know. But why were they there? If they were there for a temporary period, why weren't they removed? These are just all questions that have to be asked and answered after hearing evidence. Now, finally, I just want to deal with compelling reason for the case to proceed at trial, because limb 1 is whether there's a realistic prospect of successfully succeeding against the defendants. But
I would say I didn't spend much in the test. I think it's very obvious test for the court.
Yeah, no, I didn't. Sorry, I didn't mean like that. I meant that it's a cumulative test. So whether there is a realistic prospect of success and there is no other compelling reason. It's not one or the other. It's not either or. That's what I'm saying. And a compelling reason can be if there are circumstances that ought to be investigated. So one of them is the commercial license, how it was obtained, when it was obtained, was it submitted to the claimant? These are all questions that need to be investigated at trial. How the defendant suggests that they complied with the condition, why wasn't an addendum entered into, or why didn't D2 and D3 ask for an addendum? The intention of the parties is clearly going to be a central feature of the case. I mean, I list all the compelling reasons at paragraph 87 of my skeleton argument. I don't want to repeat them because you can read them for yourself.
No, I have it open before me. Your skeleton on another screen. Yeah.
I'm very grateful. The only thing I just want to clarify, perhaps, in that case, is how the intention of the parties plays a feature. So I'd like to look at the contract law page.
Yeah, that would be hard because we're not talking about interpretation in here, isn't it?
Yeah, so if we look at page 225 of the legal authorities bundle.
225.
Don't know if you've got it.
Yes.
Okay. So intention of the parties, Article 49. A contract shall be interpreted according to the common intention of the parties. Point here is that is only where there is an agreement between the parties as to the correct interpretation of the contract. That is a point that a learned friend cannot resolve from, because that's been dealt with by the Damac Park Towers case. That's at page 147 of the legal authorities bundle. So if we look at page 147, paragraph 80.
Yes.
In that judgment, the Court of Appeal of the DIFC court said that although 49.1 provides that a contract shall be interpreted according to the common intentions of the parties, this provision is only engaged when disputing parties have jointly put forward an interpretation of the contract. what we're dealing with here are the emails. You don't have a jointly put forward interpretation of the contract. Because my known friends says one thing, and you've heard our submissions. There's no agreement between us. So Article 49.1 is not engaged. What we then have to do is look at Article 49.2. So I'm sorry to jump back and forth, but can we go back to page 225?
Yes.
So subject to Article 49.3, if such an intention cannot be established, the contract shall be interpreted according to the meaning that reasonable persons of the same kind as the parties would give to it in the same circumstances. I don't think Article 49.3 will apply because that deals with hybrid contracts and coded contracts. So there is an objective test to be applied as to what a reasonable person, the same kind as the parties, would give to that in the circumstances. And what I say here is that objectively speaking, reasonable persons of the same kind would interpret the agreements as saying, if after we've entered into the lease agreement, after we've got the commercial license, after we provide it to the landlord, then we collectively will enter into an addendum to remove D2 and D3. That's the most sensible interpretation. Why do I say that? Because it fits in with what I was saying earlier about the questions the court has to ask. D2 and D3 are included unusually in a retail lease agreement. Why? It's one possibility is that D1 doesn't exist at the time of the lease agreement, but it might later come into existence, and therefore retrospectively is bound by the obligations of the lease agreement. So it could be reasonably said that, of course, D2 and D3 can be removed later as long as everyone agrees to remove them later. But that also necessarily means that all parties, every single one of them, actually actively seek to enter into an addendum. So when it comes to interpreting that email and assuming it is an obligation, and these are, by the way, I should say all of these submissions are on the basis that you accept that there is some sort of contractual obligation created by the email, then all it is an agreement to enter into a further agreement amending the lease. That's it.
I suppose that concludes your submission for today.
Can I deal with Article 51? Because my learned friend raised Article 51 as well.
Yeah, in a quick one, please.
Yeah. So she says, in applying Articles 49 and 50, regard shall be had to the circumstances, including preliminary negotiations, practices, conduct of the parties subsequent to the conclusion of the contract, nature and purpose of the contract, meaning commonly given, and usages. Once you look at all of this, the only conclusion is that at the time the lease was entered into, the common intention was to later consider entering into an addendum, but looking at the conduct of the parties subsequent to the conclusion of the lease agreement, nothing happened. And that's it. And therefore, that's the end of it. So the conclusion that we invite you to draw is that this application is premature. It doesn't meet the test. At best, we can deal with it at trial, although our position is reserved on this because the reality is she hasn't sought a declaration, as I've already explained, by way of counterclaim. So unless you need to hear from me any further, and unless I'm just going to check my instructions to make sure I've dealt with everything.
Please.
I'll conclude, but if there's anything in particular that I've missed, then I've just had the all clear. Those are my submissions in response.
Thank you very much.
Thank you.
Mr. Ray?
Your Excellency. May
I hope you have prepared yourself to do a recap in a short mood instead. You didn't have to go again through all of your submissions. If there is any central and important points you would like to deal with it and respond to Mr. Chadwell, then you please brief me.
Thank you, Your Excellency. I'll be extremely brief because I think everything was long enough and detailed enough. I sincerely admire the efforts that were made by the claimants to bring things in such a complicated way that the issue at stake look extremely complicated with more investigation and the need for trial. Well, obviously we disagree, and for very simple points. First, practice of DIFC and practice of DIC corporate registration companies development and action. The license is on the portal, accessible to anyone for any needs. Second, there's no possibility for a tenant to, a landlord to produce, to create, to give non-objection certificates if the company doesn't exist, right? And they were produced in dated, in 29 of August. Second point, you cannot register the lease under a non-existing entity in front of DIFC authorities. Therefore, I think it's really clear that the license was in existence. Regarding, like, I don't want to go again on the exchange of emails. I think I made my point. I think it was pretty clear. I will just add something. I mean, two things. First, my clients are French. I am also French, but it means that the primary language and understanding and concepts in terms of writing is not English. So they did meant and believe that there was a clear understanding and agreement without any speculative interpretation on the condition to sign the lease. That's one. Second, regarding the amended defense particular, you know, the thing is like the three defendants are under the claim. So basically when you answer to a claim, at some point, you need to include all the defendants. Why? Because if you don't, then someone will say, why is she not including all the defendants when she's writing? Doesn't make sense. So there were nuances. I won't go again, but I think it was pretty clear in the developments that there was a mention of the issue with the amended or non-amended contract. And to get back to a very basic principle.
I'm very sorry to interrupt. I apologize, Ms. Dre, and to you as well, Your Excellency. But Mr. Costello just had some internet problems, so he's just dropped off temporarily. I apologize for the interruption.
Appreciate your notice. Will you please bear with us? He will come back in shortly.
Thank you.
Just wait, Mr. Ray.
Yeah, absolutely.
Thank you, Mr. Moore.
Sorry, I didn't notice.
Yeah, me too.
I'm so sorry about that. I have no idea what happened. I don't know if you can hear me.
Yes, we do.
No problem.
Okay.
Mr. Kashdel will
I'm
come
so
back.
sorry. I'm so sorry about
It's
that.
okay.
Yeah, Mr. Ray, yeah.
Yes, sure. May I ask, Ms. Cordial, where you stopped? Or what was the last words you heard?
I think you probably have to start from the beginning. It was pretty early on. I'm so sorry.
All right. So now it's my turn to apologize to the court. I need just to plug my cable. Sorry for that. Yes. So I said that I would be very brief, but I did admire and I was very impressed by the efforts to make facts more complicated than they are, and the arguments of complex legal issues that are, to our opinion, not really relevant here because they do not exist. So in a very concise way, and I'm sorry, Your Excellency, if I'm repeating myself, but if Mr. Cochdel didn't hear, I have to go over it again. So what I meant is that the defendants are French, and so am I. But the thing is that eventually their understanding...
Nothing concerns you personally, because you wasn't there during the negotiation.
No, I wasn't.
It was between French and Mag, maybe in English.
Yes.
I don't know what Mr. Sabuni speaks, but
I have no idea. I'm sorry, I was not involved at
but I
that
can
stage.
tell you most of the business in Dubai are in English.
Exactly, but the thing is, like, as the disclosure documents are supportive of it, there's a lot of translation.
But
that
nothing
has to
called
be made.
nothing called French intention, isn't it? It's called parties intention. So the language is just for communication, and we can see the communication is through email. So we would only apply in maybe English interpretation to the communication between parties, Mr. Ray.
No, what I meant, what I was implying, it's that maybe they didn't look into details or they didn't see nuances.
Then that'll be the
because for
problem.
them- yeah, but because for them it was pretty straightforward. And basically, the way the emails were exchanged were for them pretty clear. So why I wanted to precise that, it's because when you talk about the expected behavior of someone, if it's obvious, why would you add more requests or more documents, right? And if we continue on the fact that things were obvious, then you cannot raise any counterclaim because the issue, you figure it out when the claim was filed. Or actually, not even when it was filed in this specific case, but when you were aware that a claim was in existence against you. Because if we pay attention to all the elements that were listed, all the arguments that were brought in front of this court, everything was pretty clear on the side of the defendants. And why even to add any additional witness statements to support evidence that are clear? Like, okay, there was preliminary condition to conclude the contract. The contract was concluded. Obviously, you cannot register a lease agreement if you don't have a commercial license under the name of a company. That's rule number one. You cannot ask any landlord to bring you non-objection certificates if you're not a registered entity, because it would be totally nonsense, right? And we have the date of those non-objection certificate on the 29th of August. So I agree that maybe the defendants are not detailed enough, peculiar enough, cautious enough, but they had a good intention. The good intention was to develop the project. The good intention was to run things fast, to start the work, the fitting work to amend the premises, to hire the company to do the work, to launch the company, to get their license. So obviously there was a clear understanding, and this is very obvious through all the communication between the parties that were disclosed in this case, that the idea was to move forward. So basically, if it's agreed, then yes, it's a done deal. And if none of the submitted documents are mentioning more than one tenant, then it is understood that there's only one tenant, which is the company. And no, there are no guarantors, because the only thing is that there was no created entity at the time of the signature of the agreement. And because they were afraid to lose the premises, and because for them it was the exact location they wanted, and it has been clearly explained on many occasions during the development of these proceedings, they wanted to be sure that they will save the spot, if I may say. So yes, contrary to Red Rose, that was an already existing company, they were added to the tenancy agreement just for the time being, because they wanted to ensure that they're going to have these premises in order to have the license, because the license address is the premises address. As simple as that. And if the license was not existing, they couldn't have registered the tenancy agreement. And if the license was not existing, they wouldn't have the NOC, they wouldn't have like proceed with all the corporate obligation they were supposed to, according to the IFC rules. And based on the exchange of official documents, including the one of Mayor Brown, I am sorry, this is not responsive. This is not responsive for the very simple reason that it's like...
Mr. Dre, I mean, let me pause here. I mean, I think chronology is a very important, especially at your application, at this scenario, this case, because of the timing of the signing, the timing of the cross-emailing between parties, because there is an obligation in your side to provide a license within the 3 months time. So chronology, I think, matter in here. I'm not saying you haven't put it. I'm not saying, I'm not forming an opinion, but I would like to kind of disagree with you. I mean, putting things in chronological order is very important for this court to interpret the course of dealing between parties, and even if you would like to say intention of the parties, and then the obligation for the parties, and what parties has to do during between I would say between during August, September, and then October. This is the 3-month time frame where supposed the amendment happened during. So from that perspective, I'm telling you the chronological order is very important.
I do agree. That's why when I started my developments, I was
No, you said everything clear. You said no matters. It's not important.
No, what
you
I
said
meant
everyone
was not...
know the license and the website. And
what I meant is because I don't want to go now into
you see, we have just gone through the license itself. We didn't know when it's issued. We have seen 3 dates in the same certificate. I say, being in the DFC for 20 years, I don't understand what's supposed to be the very official date of this license so far. But I will deal with the evidence in hand.
I understand. The thing is that on the license itself, it said it was issued on the 6th of June. By facts, we know...
You said, see, in your statement, you said once 4th of September, and then you said August one time.
I said, because the thing is that I was provided with information by my clients that are what they are, but basically I was trying to find, because it was issued in June, the 6th of June, but we know for facts that they didn't have the license operational at the time of the signature of the tenancy agreement. I was trying to find out when exactly they received the confirmation that the license was operational. So I understood because of the NOC that it might have been August. And then when I checked the certificate that I've been provided, it was 4th of September. But the date on the certificate is just the date it was printed. So that's my effort in trying to be as precise as I could regarding the license existence. But it nevertheless doesn't impact the fact that the license was in existence within the 3 months. Otherwise, all the administrative actions that were performed wouldn't have been possible.
Well, that's a burden for you to furnish, Mr. Ray.
But this is what I was trying to demonstrate during the development that we had at this hearing. And in any case, the official license is dated issued 6th of June. So if the landlord had any issue about the reality of this license, he would have raised it way before.
Yeah, but that would create another problem, because if you said the license issued 6th of June, and even if you said the the license issued anytime before the official signature of the given contract nowadays, and that would create problems to your own submission about the addendum or the amendment of the contract itself. You see, that's how that's timing is very, it's very important.
Where you're directing, but
you see where Mr. Chad will come from. Yeah.
Yes. So the thing is that the amendment, because it was implied and it was confirmed by emails, and it was in practice the understanding of the parties and at least of the defendants, like there was no point in raising any default or non-performance or fundamental non-performance, because according to them, it was something that was already operational. And that's only where they were aware of the claim and that they were like personal party in this claim, that they understood that the amendment on the side of the claimant is not considered amended anymore, if I may say, which was contrary to the initial understanding. And
anyway, Ms. Dre, anyway, we got only 3 minutes before we start this hearing, because this hearing is supposed to be for 2 hours. We're going for 3 hours now. And unless there is any final remark for you.
The conclusion I will just made is that the position is like it's basic contract law, that the criteria were made, and because it's a very simple contractual issue, the criteria for immediate judgment were indeed met in this application, and we don't see any reason why it should be brought to trial, because it's not even listed in the issues.
Thank you very much. Chadwell, I think I have your submission as well, both orally and written submission, and I will look at it in details, and I shall deliver my decision soon. If it's not soon enough for me to deliver a reasoned judgment, I might start with delivering a judgment with reason to follow.
Exactly.
And then I will deal with cost later on, and I have your cost certificate as well. Is there any request by you to submit after receiving my reasons to comment on cost submission, for example, or something?
Firstly, we would be grateful if Your Excellency would issue an order with reasons to follow, because there would be necessary implications for how we go from here. I know that D2 and D3 will likely give evidence, but if as in witness statements, and we're at that stage soon. But all parties need to know if we're dealing with this issue in any more detail, because if you accede to my own friend, then it's not an issue. But if you don't accede, then we'll probably have to deal with it. Secondly, on costs, you've got some basic submissions from myself, but I don't know. It rather depends on what your consideration will be. But normally costs follow the event anyway. So, and you've got the statement of cost. I don't think you've got the final statement of cost from my learned friend though. That's the only issue.
Oh yeah,
But she can provide that.
Yeah, I have received yours. Yes.
Well, what I would suggest is, depending on the order you make, a final statement of cost can be issued. It can be submitted depending on which side wins within 7 days after, if that's required.
Yeah, sure. If there is necessity, I would invite you for short submission as well.
Yeah.
I agree with my colleague on that. It will be very helpful, and it's also, yes, provisional cost, so it was not the final.
Then what's left only to thank you for your preparation for today, and the team behind. Thank you very much for everything.
Thanks to everyone.
And you'll hear from me soon. Thank you very much.
Thank you.